We've made a convincing case.
Yes.
That we are right in 2025.
Yes.
Because January, which is deemed to be the difficult month, is gone.
Yes.
January is difficult because you see it's a lie. It's not 1 month.
Mm-hmm. It's all 12 months in itself.
When they give you a discount, it's around 4 months.
Judge Karibu Sana, it's good to have you here.
Thank you so much.
We want to understand the Environment and Land Court. We know there's some new developments of what you've done internally in making sure that this court then delivers justice better, more efficiently, faster to people. You serve in the Land Court at Milimani. And you tell us.
I serve in the land division.
In the land division of the Environment and Land Court. That division is what we want to know. So this division, what does it mean? So, but Karibu for the conversation. City is going to give you the day's proverb, courtesy of EcoBank. EcoBank, you know it is a Pan-African bank. It is in very many countries. How many countries, Ndu?
33.
How many in Africa? How many outside?
33 countries in Africa and 7 countries outside of Africa. So in Europe, we're looking at, I'll tell you in a minute.
Okay.
France.
Yes.
UK.
There you go.
I was about to say Dubai. Then Dubai is not in Europe. Yes.
So not just in Europe. Sorry, those 7 countries are not just in Europe, but outside of Africa. 7 countries.
Yes. So how many? Which countries are those again? City? France,
China.
UK, China. Dubai,
UAE is what you're looking for.
How many times do you want to count these numbers, Eric? Have I not just mentioned all of them?
You've only said 4.
If you can't count, it's not my problem.
Surely, man. If you're in 2025, surely you can say the 4 and 7.
Surely, Eric.
Sawa. And how many staff employed by EcoBank?
14,000.
14,000 staff employed by EcoBank, serving you across the continent. So EcoBank then also supports CT in going across Africa to one country in Africa, and he gets proverbs from that country.
Yes.
This week you're in?
The country of Zimbabwe.
Right.
Yes, a very interesting country, as I keep saying. The only country on this continent that at its independence, which was the UDI, had a white prime minister, meaning it had a head of state who was absolutely white, a gentleman by the name of Ian Smith. Yes. But that UDI was rescinded at some point, around 1979. That UDI was 1965. Then Rhodesia became Zimbabwe. That was really 1980. An interesting country, this one. Very, very interesting. Now the proverb, a coward has no scar.
A coward has no scar. Justice Ogutu.
Yes.
What is your interpretation of this proverb?
My interpretation of that proverb connotes that, if you are a coward, then you don't have to confront any battle. And because you don't confront a battle, you don't accrue any scar. So you are blameless.
So is it a good thing or a bad thing?
Well, in my view, life is a journey. Being a journey, there are very many encounters that one must go through, some of them very bruising, some of them not very palatable. But you must allow me to say this, contend with all those situations. And in the course of it, at the tail end, you will accrue scars. So it is not a good thing to be a coward.
Not a good thing.
In my humble view.
It means that you're just floating through life.
Yes.
Okay.
Or running away from it.
Or running away from life.
And they say success doesn't belong to cowards.
Now, Judge, we've had conversations with several of your colleagues from the Environment and Land Court. We understand it's a superior court created by the Constitution, equal to the High Court, specifically dealing with environment and land matters. And we have talked about many times, what does it mean, environment and land matters? How many cases do you face in court and all? But it's been at least 10 years since this court was established. Let's go into which of those...
You perhaps need to add one more year on
11, eh? Yeah, 11 years. We are in the 11th year or in the 12th year?
We are getting into the 12th year.
Yeah. So, between environment and land matters, how many do you actually find yourself dealing with most? And is there a reason why?
Allow me to point out that, yes, it is a superior court. 2, that it is a court with equal status with the High Court, but status does not mean that they have same jurisdiction. Their jurisdictions are different and delineated by the Constitution. The status is just in terms of the judges. They are all peon judges. They all accrue same terms, most probably same remuneration, but in terms of jurisdiction, the Environment and Land Court is established by dint of Article 162(2)(b). And it is specialized in nature, and it deals with environment and land matters. In this dichotomy, land matters, and as you very well and we very well know, are politically sensitive, culturally complex, and very emotive. They say very emotive. So in our country, because of the love for land, the land cases far outweigh those with environmental inclinations. So at the Milimani ELC, the number of land cases, those are disputes that pertain to title to use of or occupation of land in its diverse perspectives are more than environmental matters.
Okay.
And perhaps I may also wish to add that environmental matters are complex in a way because they require scientific interrogation, which the ordinary persons perhaps are not able to gather, to get to. That's one. Then 2, many a times human beings look into issues as to what do I get out of it. So in land disputes, you see, you're fighting to protect your interests, mine.
Yeah.
But in environmental issues, they take a different dimension. So they really, yes, they do affect you and me at our personal levels, but then they have a wider perspective, and therefore many a person do not, just extremely very few. Remember Wangari Maathai, and how many Kenyans were with her. You notice she was one of the founding environmentalists, right?
Yeah.
And for a long time, perhaps the sole voice speaking for the environment. So it continues to subsist. The number of environmental matters that we have are not quite many. Indeed, allow me to point out that the establishment of the Environment and Planning Division was actually intended to foster a scenario where we could create awareness and cause Kenyans and many other persons to partake of this right provided for under Article 42. The right to clean and healthy environment. But still, the number of cases are not
as many.
Not as many.
Okay.
Perhaps in comparison should be 2 to 8.
Oh, wow.
2 environment to 8 land cases.
8 land cases.
Okay.
Okay. When we look at some of these cases, and we just hear of the land cases that, whether individuals have brought their cases to court, the element of time comes into play. And I guess a very simple question is that time being a factor, why do they take such a long time to adjudicate?
Now, allow me to start from a dimension that before Kenyans, you and me, ultimately voted for the current constitution, the Constitution 2010, land matters were lumped together, heaped together with all those other matters, criminal cases, civil cases of different dimensions. And given the three critical issues I alluded to, one, politically sensitive, culturally complex, very emotive. You notice they pit mother against son, son against father, brother against husband against wife. That denotes how emotive they are. But the point is that in the time when they were lumped together and they were being dealt with by the High Court, they were not being prioritized, perhaps informed by these three critical issues. And then two, the land law regime that was hitherto obtaining in Kenya was also a little complex, because we had assorted regimes governing land registration, land administration, land use, and the registries were also scattered across. We had the Registration of Titles Act, we had the Registered Land Act, we had the Government Land Act, we had the Trust Land Act, we had the Group Representatives Land Act, all of them with different dimension. And this created a bit of a difficulty. But then fast forward under the Constitution towards harmonization, we then now only currently have two operative land law regimes. There is the Land Registration Act and the Land Act. This has harmonized the process. This is towards fast-tracking the hearing and determination. This is towards making it easier for you and me, without legal knowledge and training, to be able to appreciate. And this difficulty also contributed. But then again, the other reason that belies the amount of time is also the amount of cases. They come in various perspectives, various dimensions.
For example?
You and me fighting over ownership of land. The other one, you taking an aspect, a criminal aspect, for forcible detainer or forcible retainer. You taking a criminal action for trespass. You and me, or me and her, fighting over matrimonial property. All these, and they are interlinked. And there is also the succession aspect. So all these, you would find a dispute is in the succession court, fighting over land. Someone has clothed it differently and walked the same dispute or near same dispute to the land court. It's just a question of a perspective. You twist it this way, twist it this way. So this creates a quagmire of sorts. So all this, and then you and me also are aware that the number of judges vis-a-vis the current population, because even at this juncture, the current Chief Justice has a blueprint called Social Transformation through Access to Justice, which is more people-centered, right? Which is geared towards effective service delivery. And one of the key pillars is an endeavor to render real-time justice, hear and dispose of these matters within 365 days from date of inception. But then looking at the number of judges vis-a-vis
the population and the cases,
it's not a reality, and this is the reason why we keep talking about more funding, more judges.
So the Environment and Land Court, if we're looking at now the lands aspect, do only sit in Nairobi? Or is there avenues to have some of these cases sat in other parts of the country?
Perhaps one thing that you need to appreciate is the Environment and Land Court is not only sitting in Nairobi. We have judges sitting across, I think, 37 counties that have judges. our endeavor is to ensure that each and every county has an ELC judge towards decentralizing, or is it devolving judicial services? So we are not only sitting in Nairobi. Currently, we are 8 ELC judges sitting in Nairobi, but with effect from the 1st of March, we will be 7, because one of us has since been relocated to Voi, so that Voi, this should be Taita Taveta County, would now have a sitting ELC judge. So we sit across the country.
There are alternate mechanisms for attaining justice, and they've been spoken of at great length by some of your colleagues who have come here. Please walk us through how this can and or does work out in the court that you represent.
Yes, maybe allow me to start from the perspective that this alternative justice system is not only a creature of the Constitution, but is now a constitutional imperative.
Yes.
It is underpinned by Article 159 2C of the Constitution. Perhaps you and me, I say you and me because we both voted for the Constitution. This was a Constitution that we subjected to the referendum, and we voted, and we said this bit is good. We came to the realization that the old thinking that disputes can only be sorted out and handled by the judiciary was outdated. And this then brought to the fore the expansive thinking that brought on board the alternative justice system. It does work for my court, and I will, before I get there, allow me just to break them down. When we talk about the alternative justice system, these are those systems that are geared towards achieving and rendering justice to the people without necessity of approaching the court. There are a myriad of them. There could be one where we call reconciliation. You and me had a dispute, but we can sit, talk, and that is reconciliation. There is mediation, which would require the intervention of a third party sitting to help us patch up. Then there is conciliation, which is many a times used in the Employment and Labor Relations Court, which is the twin court to the Environment and Land Court, but deals with employment and related issues. Then there is also the court-annexed mediation. And then we have the traditional dispute resolution mechanisms. So long as there's a caveat, the mechanisms are not repugnant to the Constitution and the constitutional principles. For my court, taking into account the diverse and complex and sensitive nature of issues that do arise, alternative justice system would suffice. And I did mention land disputes because land is stagnant, but the population is growing. So each and every one of us is yearning for peace. We've gotten to a scenario where you find mother against son, or son against mother, father against daughter. All this. So these are disputes that concern land, but having a domestic perspective. In this kind of scenario, taking into account the necessity to foster relationship in this family, an alternative justice system would work better and be efficacious than our adversarial system. Ours is you and me are adversaries. The judge moderates. And there is no draw, 0-0, 1-1. No, there must be a win, which must be proclaimed. You like it or not, but you see, that is the nature of our system. But the alternative justice system has a window, perhaps a door, for a win-win situation.
How effective is it in terms, because cases don't start in the courts, they end up in the courts. So a problem arises in some place over land. Like in the last year, one in Machakos, before you knew it, there's another one in the easterly parts of Nairobi, people. And that's just the tip of the iceberg. There is no part of this country where one doesn't hear of a problem with land. I wanted to understand these alternate resolution mechanisms that we have, how effective are they in places where, forget these large ones, those ones have to go to court, there's no question about it, I understand that, but